I'm very pleased to have Ian and Susanna to lead today's webinar, and I'm going to turn it over to them. Thanks, guys.
Thanks, Jordy. Hey, Susanna.
Hi there, Ian. Hello, everyone.
I'm just going to, I don't have any bandwidth problems myself. Okay, great. So today we're going to talk about sort of that classic case of Pecore, but we're going to drill down on it a little bit to sort of set the stage to this important parameters that are established in trust law through the Pecore decision and other aspects of trusts that come out of that decision. We're going to talk a little bit about the concept of advancement. And as I say, we'll maybe dissect Pecore a little bit and then talk about rebutting the presumption and what does that look like and how do we go about it. So as we know, there are certain kinds of trusts that arise by operation of law because they're imposed by law regardless of the expressed intention of the parties. And that's what resulting trusts are all about. Resulting trust is imposed in certain situations to return property to the person who gave it and is entitled to it beneficially from someone else who has title to it. So we always want to split the title, and we want to the legal title aspect of property and the beneficial interest aspect of property. So the beneficial interest results, or it essentially jumps back to the true owner. And the resulting trusts are sort of, there are two kinds. There's one that's an express, where an express trust fails in whole or in part for any reason. Or there's those that where a person makes a voluntary transfer of property and to another or others and purchases the property. And the title is taken in their name, in the name of others or others. So this is the sort of the basic parameters of what we're working with. Now, Susanna, why don't we turn to the concept of advancement and resulting trusts precisely now?
Sure, Ian. So when we're looking at gratuitous transfers of property, these are the two presumptions that can typically come to light. And that's because ultimately, when you have a gift, there's this, the ultimate question is, what was the intention? Was it in fact to gift the property to someone, or was there some kind of reason why it would actually revert back to the owner because that intention doesn't actually exist? And so when we're looking at certainly a presumption of resulting trust, the court's going to infer in that situation that no gift was actually intended. Whereas when we're looking at, the presumption of advancement, in those instances, then a gift is in fact going to have been intended. So what we're really talking about is in those situations where we don't have that direct evidence intention of actually wanting to gift, how do we decide what it was that the donor or the testator actually wanted? And that's when we call upon these presumptions, which of course are rebuttable and only apply when that evidence is not clear.
All right, so when you talk about presumptions, can we talk about specifically presumptions of advancement where we're dealing with transfers to children? Well, let's take away the spousal transfer scenario. Let's talk about transfers to children.
Sure. The presumption of advancement historically only applied to transfers made from a father to a child. And that presumption developed this way because historically a father had this moral duty to take care of his children and to advance them in the world and basically to lead them on the road to financial independence. Interestingly, of course, transfers from a mother to a child were not included under the presumption historically, and that was because mothers weren't under that same kind of duty to provide for the children. Today, however, in recognition of the fact that both parents are so integrally involved in their children, the presumption actually applies to both parents equally. And in certain instances, the presumption can also be extended to situations where someone acts sort of in loco parentis to the donee, and in that case would also be under a duty to make provision for the child. So although historically the presumption was that it would apply only from a father to a child, and in those circumstances it applied regardless of the age of the child. Didn't apply to the mother, but it does now. And that's where sort of Pecore comes in terms of changing that and being as important to us as it was back in 2007.
Yeah, and it's interesting. I mean, Pecore did change the law in some respects, but also restated the law, because the issue considered in Pecore in that case was whether the presumption of advancement should continue to apply to all gratuitous transfers from a parent to child, or whether there are circumstances where the presumption of a resulting trust ought to apply instead. And we've got some real clarity on that. Maybe, Susanna, just because it's always handy to get, especially with an important case like this, to get some of the key factual background of the Pecore decision, because it helps sort of delineate what you're saying.
Right. So in this case, the father gratuitously placed his investments and his bank accounts into joint accounts with his daughter, based on advice from his financial advisor that, this would avoid, of course, having to pay probate fees and taxes on the accounts at the end of the day. So the daughter never actually contributed any funds to either of the accounts, though she did from time to time make some withdrawals before her father passed away. The father paid all the taxes on the accounts during his lifetime. And in order to avoid having to pay capital gains tax, he actually wrote letters to the financial institutions confirming that he was actually the 100% owner of the assets and that they were not gifts to his daughter. Now, he went on and later created a will, but never actually addressed either of the investment accounts or the bank accounts and didn't include them in his will. But he did from time to time tell people just before he passed away that, yes, he had made provision for his daughter and that she was going to be all taken care of. So in that factual matrix, the court had to decide whether, when the father passed away, he actually intended to gift the beneficial interest in those accounts to his daughter on his death, or whether she was actually holding those assets in trust for the benefit of the estate. And depending on which result was going to come into play, there was a really big swing in favor of the daughter. Because if in fact she was going to get everything by right of survivorship, then she would have been entitled to everything, wouldn't pass through the will. But if it was going to come back and revert back to the estate by virtue of a resulting trust, then she was going to have to share it with her ex-husband, who was also a beneficiary under the will.
And so before we look at some of the analysis that comes out of the decision, let's just highlight these fundamental aspects of what the court was looking at, because they almost always arise in cases where we're trying to determine whether or not Pecore will apply to our own cases. And in that case, we've got questions of contribution, who's making the contributions into the accounts, what's the activity on the account, who's using it, who's not using it, who's paying the taxes on the accounts. And that's important when you get into a situation that, of course, where you're looking at what you want to get looking at the tax returns that were filed, and then the behavior of the parties, each of the father in this case and of the daughter. Now, that's what the court, we're going to talk about in the analysis, really started to look at was what was the behavior beyond the sort of clinical steps that were taken by the parties. So maybe let's just spend a minute looking at the analysis of the decision, Susanna.
So interestingly, the case was not unanimous. There was a very strong dissent, certainly, but the majority of the Supreme Court of Canada held that the presumption of resulting trust ought to apply to all gratuitous transfers of property from a parent to an adult child, and that in this case in particular, it was going to apply on the facts as the court found them. So whereas previously there would have been this presumption of advancement and it would have been a gift, here the court said when you have an adult child and the parent transferring assets into joint tenancy with an adult child, in that case there's going to be this presumption of a resulting trust, that they're holding that for the benefit of the estate. Now, Justice DeBella wrote the dissent, and she wrote a very strong dissent in favor of actually upholding or continuing to uphold the presumption of advancement the way that it was before, in that any gift from a parent to a child would be presumed to be a gift. So in terms of the overarching principles of the case, Pecore really does confirm that both the presumptions of resulting trust and the presumption of advancement continue to play an important role in these cases, And, the court basically used it as an opportunity to provide sort of a guide to the courts on resolving disputes where the transfers are made in situations where there isn't clear evidence of the actual intention. And when you have to fall back to these presumptions, the court was trying to give us some guidance in terms of how to apply them and how to make that ultimate determination as to who should be entitled to something on the death of the surviving joint owner.
And these, as you say, these presumptions really provide a measure of certainty and predictability for individuals who put property into joint names or make gratuitous transfers. And so the presumptions, the concepts really matter. And that being said, too, Pecore also marks a sort of a significant shift in the law, because the majority held the presumption of advancement now only applies to transfers from parents to their minor children and not adult independent children. And I think that's where I would say some new delineation of the law came out of it. What was sort of the rationale for the change in the law, do you think, Susanna?
Well, I think the court really recognized that it is commonplace for aging parents to have their children help with their financial affairs. And in many cases, we see situations where these accounts are being put into joint names or properties being held jointly. And the court recognized that, there's a variety of ways that a parent can empower their child to deal with their assets. They can, for instance, execute a power of attorney, or they can add a child's name to a parent's bank account or other assets. And the majority basically just recognize that, simply because a parent adds a child to their accounts doesn't necessarily mean that they intend to gift it to that child. It could be just as a matter of convenience, and in many cases it is. And so the court really recognized the need to delve into, what was actually intended at the time when the transfer was made or that the person was added jointly to title. And the court also held that, one of the key rationales for the presumption of advancement, which was that the parent had an obligation to support his or her dependent children. Well, the court said, well, you know what? In this day and age, that doesn't really apply to adult children. And therefore, that was why it sort of limited the presumption of advancement to only minor children and not adult independent children or dependent children.
All right. And so I guess, Susanna, then you mentioned, though, the dissent of Justice Abella. And the fun thing about when you can spend a little bit of time considering these decisions is to look at the impact of dissents, because they still have this sort of long tail. The impact of the dissent, and Justice Abella's dissent in Pecore, although it doesn't totally represent the law, it was an interesting analysis where she jumped in. Do you want to just make a couple of comments about her moments in time in that regard?
Yes, I mean, she really did, as I say, try to step back and to keep the presumption of advancement on par with where it was before, which is that it applied to children, period, between parent and child, regardless of minority or dependency. And she focused on the fact that, historically that affection, that, that caring for children was the solid basis to ground this presumption. And she felt that that should continue to be the case. She said, we shouldn't be focusing solely on whether a child is dependent or independent. She said it was equally plausible that a parent would want to gift money to a joint adult or joint ownered child, joint title holder, and that in those cases, it would be an expression of gratitude rather than just for convenience. She said, if you're going to put someone on title, then it could be because you really do want to thank them and reward them for taking the time to assist you with that. And in that case, she thought the presumption of advancement should be the one that governs. She said also, of course, that, if a parent doesn't intend to actually gift, there's other ways to deal with their assets where they don't have to put them into, joint ownership. They can, give them authority to deal with their assets by virtue of a power of attorney, or they can create perhaps a bank account without the rights of survivorship. So she was recognizing that there are other means to which, you could really look to plan for these situations, and you don't just have to, automatically and maybe arbitrarily decide that someone cannot be entitled to something simply because of their dependency or their independency as an adult child.
Well, that's great. All right, so let's talk about the practical impact of this decision, and that is sort of analyzing, rebutting the presumptions. and looking at what the courts talked about in Pecore in terms of what they looked for necessary evidence to rebut advancement, rebut the presumption, but also what is it, where does it leave us today in our day-to-day practice when we're looking to try to see if in a circumstance exists with our day-to-day clients, if whether or not Pecore is going to apply or not.
Yeah, the key really is going to be whether or not there's direct evidence of intention. If there is that intention evidence, then a gift's a gift, and we don't ever have to turn to the presumptions. But if there's evidence that perhaps the transfer was in satisfaction of a debt, or there was some kind of a loan or a sale, then in those cases, with the consideration that was provided, neither of these presumptions is going to come to light. And similarly, if there is evidence, if there isn't evidence of the actual intention, or it's insufficient, it's not, determinative, in those cases, then we're going to turn to these presumptions to see how they apply and whether or not they can ultimately be rebutted.
And what's the importance of the application of this in the context of it being a gratuitous gift?
It's simply that, because, equity presumes bargains, not gifts. And so in those situations, if it's not crystal clear that, and we've talked about, the fact that sometimes you need a deed of gift to say it really is a gift. I think that was your language in the past. In those cases where we don't have that and we can't say definitively, that's when we're falling back to these presumptions and, applying either the advancement or the resulting trust analysis, depending on which way you ultimately want it to go.
All right. So, and then just thinking this through, I really mean it is what I always say when we have to look for the evidence. But often in our cases, we don't really have, as you say, determinative, I really mean it evidence. Sometimes it can be identified in the will. Sometimes it's ideally in a separate note. I remember years ago, Jordy, of course, started a product, jointassets.com, and it helped us direct us to how we would structure the documentation of I really mean it notes with these joint accounts. But with respect to the presumption of resulting trust, intention is only relevant though if the transfer is actually made. And that's sort of a starting point that I always want to say. Like it's sort of like, what was it gratuitous? Was it a gift? And then it only becomes relevant if the transfer was actually made. So when we're dealing with the presumption of advancement, where the presumption is that the gift was intended, the presumption can be rebutted though in numerous ways. Do you see any other sort of practical day-to-day tools that you use to ensure that your clients, for example, when they set up a joint account with their child, can do to assist us litigators when the day comes to determine whether or not it's actually passes through the estate or to the account holder, and more importantly, what are some of the things that the Ontario government's looking for as well, that they want to know whether or not this is actually a Pecore situation, because that's where probate tax comes into play.
Yeah, I mean, the presumption is definitely going to be premised on, direct evidence of intention. Will avoid the need to apply the presumption. But if there isn't that, then particularly in the cases that we're seeing when someone's passed away, we're going to be looking at intention that actually matters is the intention at the time that the transfer was made. So whatever happens subsequently may not necessarily be relevant, but it may be, depending on certain situations. But the key really is that it's the donor's intention that matters, not the recipient's intention. So regardless of what they think, we're going to be looking at what was intended when that transfer was actually made. And there can be situations where the circumstantial evidence might speak to that. So even though we don't have the direct evidence, the circumstances in which that gift was made can be taken into account. And also even subsequent events after the actual transfer took place can be brought into and perhaps determine what it was that was the intent when the asset was made into joint names or transferred or gifted. So this kind of evidence can be important and help ultimately make that determination and as to whether or not the presumption is going to stand or be rebutted.
And so it's always helpful for me when I look at this, and now that we've sort of done a deep dive into Pecore and resulting trusts, I like to also analyze it in the context of what it isn't and what it is. And what it isn't, of course, is it's not a constructive trust. And a constructive trust does not mean that the court constructs a trust, of course. It's rather it construes the situation as revealing a trust. And that's a very important distinction between what a resulting trust is and what a constructive trust is. And it really, and again, constructive trusts as opposed to a resulting trust have nothing to do with intention. It's imposed by the law to prevent an injustice. And it's always interesting to me to see sometimes in these resulting trust cases how, of course, we have to keep the two concepts separated, but how equity sort of plays around with that because it sometimes looks for the injustice in the resulting trust scenarios. And that's where you were talking about the nature of the evidence. That it's a bit of an elastic band, but how far will the court stretch to say, yes, I have sufficient intention evidence. That's sufficient intention evidence. And so I guess from my standpoint, it's always important for me to sort of juxtapose resulting trusts to constructive trusts, because of course, constructive trusts are most often arise when you have a fiduciary relationship. And a trustee beneficiary or a solicitor and client or an agent principal scenario or company director, those kind of situations. And it, of course, can be imposed to strip that fiduciary of a gain made from the relationship on which conscience belongs to the beneficiary. But a fiduciary relationship is not always required for constructive trust to be imposed, but it's just important that it's used to reverse this unjust enrichment. Whereas resulting trusts, it's a very different analysis. But factually, I see the courts playing with the same sort of tools sometimes, looking for where's the injustice here. And if there is an injustice, to having it pass through the estate, given all the circumstances in a resulting trust question, or not. So anyway, that's just sort of a general observation I've seen over the years when I've been watching how these cases are sort of being analyzed by the courts. Did you have anything else to add on the resulting trust piece, Susanna?
I was just going to say that when we're dealing with these situations and that determination is going to be made, I mean, both sides are going to want to lead evidence in support of their respective positions. So it's not just like one party is going to come in and say, I have the presumption, therefore I win. Both sides are going to try to lead their case forward so that, the party that's alleging a resulting trust is going to have to show that a gift was not intended on a balance of probabilities, of course, a civil standard. And when we're dealing with a presumption of advancement situation, then the other side is going to try to demonstrate that a gift was not intended, again, on a balance of probabilities. So, it really does come down to a judge weighing the evidence and making a determination as to which side he or she feels has the better evidence in support of intention. And then they have that elastic, attempts to make sure that they're writing things properly, writing the wrongs that could otherwise be done, as you just alluded to, Ian. And that's where they've got that flexibility, I think, to do what they ultimately determine as, the right thing to do.
And it seems to me a really simple way to resolve this continues to be create strong intention evidence. So from a planning standpoint, it's not that complicated. If you identify the asset and you create either in the will or a sub document that identifies the intention, it's going to go a long way to resolving the resulting trust piece. It's where there's silence and what you're trying to do is look at around surrounding circumstances and things like that, where we're having to stretch as lawyers to find the right answer, is where the courts are going to struggle. And quite frankly, it may land the wrong way in terms of its distribution. But Jordy, I know you're online, and maybe did you want to announce anything for next week's seminar for eState? Probably, maybe he's not online. He was earlier. He always likes to audit me. Okay, so I think we're just about we're just about at the end of the time. Susanna, do you have anything else to add on the resulting trust piece? I know I threw in some constructive trust there, but I think it's important to keep those two concepts delineated, and today wasn't all about constructive trust, it was about resulting trusts.
Absolutely. I think I just would sort of wrap up by saying that, you know, any particular factual circumstance can't be subject to both of the presumptions. So it's going to be one or the other. Either you're going to have a presumption that there was a gift or that there wasn't. And the fact that you demonstrate that one of the presumptions is overcome doesn't mean that the other one just springs to life. It's only one at a time. And that's why these cases, as interesting as they are when we read them, are really so factually driven that it's hard to necessarily be able to say that this case is going to be completely binding on every single situation like that, because there's always that nuance where one factual discrepancy can make a very different result. And so I just sort of throw that out there in terms of my own observation of the cases and how they can be applied going forward.
All right, well, that's great. Well, thank you so much, Susanna, and we'll be back next week, or I'm not sure who's on for next week, but we'll get the announcement out shortly. Have a great weekend, everyone, and thanks for joining.
Thanks very much, Ian. Thank you, everyone. Have a great day.